How is everyone this evening? Good? As good as we can be on a Friday at 6 o'clock, right? First thing I want to start off with, John, Mike, and I wanted to mention a few things. This is a statewide issue. This is not just the Skagit watershed. This truly is a statewide issue. We're here to present the facts to you, and it is a very confusing thing that has happened, particularly in this watershed. A lot of twists and turns, a lot of people have been involved. And we honestly are unable to cover everything tonight, but we're going to do our best to be as concise as possible. And as John said, we're here, we're going to show you that really the basic arithmetic used is wrong. The arithmetic is truly wrong. We don't put the blame on any one person specifically. We can't blame one entity versus another. Virtually all of the people, all the stakeholders, Skagit County, ecology, the tribes, PUD, Anacortes, everyone bears a little bit of responsibility in this situation we have. So we need to be very clear that it's not a tribal issue. In fact, the Upper Skagit is working on a mitigation solution right now in Fisher Creek, and we'll talk a little bit more about that later, but be very particular, this is not a tribal issue. It comes down to a lack of leadership and accountability amongst the stakeholders. I think the one thing that I've learned over the last 3 years that, the narrative, you're finding the narrative about habitat, we don't care about habitat, we just want to build our homes. I've not run across one person that doesn't have a concern for the habitat. In fact, as taxpayers, we've all spent millions of dollars, I think close to $250 million in this watershed alone for habitat. And I don't think it's too much to ask for taxpayers to get a piece of that water for paying for all that. So I do thank you for all being here, and I'll get started now. So we're going to talk a little bit about the basics, just some basic terminology, the history, the science, and I put it in quotes because it's more just poor arithmetic versus poor science. The stakeholders involved, the mitigation, a little bit of that, fish and people, as John mentioned. A few of the takeaways we want you to get from this evening, be able to go home and understand what's happened. And if you want to help, we've got some directions there. So the basics. This is about well use. And I promise this is the worst slide. There's a lot of information on here, I know. It's about your well use. Specifically, how much water are you using? Now, the state average is about 350 gallons a day, but with a normal permit exempt well, you're allowed upwards of 5,000 gallons a day. No one uses that. The average is 350. Hydraulic continuity. So how connected is your well to that stream? And how much water from your septic system is actually going back to the system? So those are kind of the three things that have brought all this about. They're concerned about your well use. And because of that, it's the habitat impairment. Your well use impacts habitat. To protect the habitat, they came up with a minimum in-stream flow level. It's basically a water right for fish. So the way you can think about it is that the river goes up and down, and they put a benchmark, minimum in-stream flow. They set it saying this is what's required for fish to survive. So the river will go up and down. This is what's required for fish to survive. To put that into regulation, they did the 2001 in-stream flow rule here in the Skagit watershed. And as a part of that, they put in senior water rights. So Anacortes, PUD, and agriculture are the main water rights holders. So they include that. They say you're non-interruptible. If the river, the minimum in-stream flow is here and the river's going up and down, if it goes below that minimum in-stream flow, that water right, that senior water right, is non-interruptible. They can still pump water. And any exempt well use prior to 2001, you're part of that senior. You're not interruptible. Post 2001, what's come about is the junior water rights. That's kind of evolved from the 01 rule. And that's pretty much all landowners and farmers post April 14th, 2001 is the date. But you're considered interruptible. So the reason we're all here is if the river goes below a certain level, you can no longer use your well. You're interruptible. You need to mitigate for your water use. That is theoretical impairment. So they're counting molecules of water, and that's what the goal is to have zero theoretical impairment. So kind of think of it as a regulated drought, and I'll get into that a little bit later, but trucked water, rain catchment, or some other proof that you're not impacting the streams. So what started all of this? It's the 1996 Memorandum of Agreement. I'm sure most of you have probably heard of it. It's been referenced in the paper a lot, but Ecology, Department of Fish and Wildlife, local tribes, Anacortes, PUD, and Skagit County were all involved. Why did they do this? We have the third largest watershed on the West Coast. Columbia, Sacramento River, Skagit River. Got a lot of water. They wanted to protect it. King County had kind of expressed some interest, and they needed to safeguard the water here. Wanted to benefit the citizens and the habitat, and last but certainly not least, they wanted to protect the tributaries. Tributaries were a concern for fish. Now, in general, it's a it's a good idea. It was a agreement to protect everyone's water. Well, after 5 years of research, there are 4 important things to take out of that rule. The first is that they have 5 measurement points that they've used. They've set 5 minimum in-stream flows. One is on the main stem of the Skagit. It's at the bridge that fell in between Mount Vernon and Burlington. It's over there. The other 4 are on tributaries. Out of 2,900 tributaries, those 4 serve Skagit PUD's reservoir. So out of 2,900 tributaries, only 4 have a benchmark set. Second, the summer minimum in-stream flow level is 10,000 cubic feet per second. I'll get into that a little bit, but just remember that number, 10,000. That's that flow of the river. The third thing that they did was that future well use was excluded from it. So you've got PUD, you've got Anacortes there at the table. They were very instrumental in creating the 2001 in-stream flow rule. And they said, well, hey, we got to protect our water rights. We need to protect our water rights for future planning. Conversely, for exempt well users, such as yourselves, that are de minimis use of water, they excluded it. They said, nope, no water for you. The fourth thing is that one of the ways they did that is they have 100% assumptive impairment to the remaining tributaries. There was no science done on them. They just said, your well is hurting them, so you can't use your well. So basic water rights in the Skagit watershed. That's what it looks like. Fish habitat has 10,000 CFS. City of Anacortes, which is, agriculture combined is 105. City of Anacortes 85. Skagit PD 42.5. Farmers and landowners after April 14th, 0. Now, what if we would have had a piece of that pie? What if they would have included well users? I'll get into why 10 CFS later, but that's basically what would do it. If you can see, it's right there. It's that little bit of slice right there. There was no other watershed in this state that has this unbalanced of a pie chart, period. But remember, you don't have that water. So this was a problem in 2001. Skagit County was like, wait a minute, we don't agree to any of this. And they proceeded with litigation against Ecology. Well, they worked together, came up with the 2006 amendment, which you've probably heard referenced. And I'm going to speed through kind of the next 12 years. I'm going through history here. But they tried to fix the 2001 rule, sued Ecology. Ecology said, let's work out a deal. So they came up with the 06 amendment, which was the most restrictive solution for exempt wells in the state, or in the country, actually. Example, Carpenter Fisher had enough water set aside for about 33 homes. Obviously, that resulted in a building moratorium because 33 homes were built over about a 5-year period, and it triggered the closure. In the meanwhile, the Swinomish tribe, along with support from Anacortes and a bit of neutrality, maybe forced neutrality of Skagit PUD, 7 years of litigation, moved forward to last October, which is why we are all here, to the Supreme Court ruling that invalidated that 06 amendment. They wiped that water away, got rid of it. And you need to know it wasn't due to science, it wasn't due to fish are dying because of this, it was due to a technicality of how Ecology implemented the rule. And so we have a return of the 2001 in-stream flow rule. So what does that mean? It means all junior water rights users, there's about 5,700 landowners and 600 homeowners, and getting a precise count on either of those is really difficult. Trust me, we've tried. But it's approximately that. Within the confines of that purple line, the watershed, all the way back, Ross Lake, up into Canada, the whole confines of that, you need to mitigate for your use during times where the river goes below that benchmark. How did this happen? Well, there's a few reasons. There's a number of reasons how and why this happened, but I'm going to give you 4 examples. The first one is that ecology just simply set the bar too high. That minimum in-stream flow level is that red line. That's what they said the fish need for habitat. When they created the 2001 in-stream flow rule, they went over a 54-year history of the river and said we need to make the rule for those years. It was 1940 to 94. So I took the median flow of the river, 50% of the days the river's above that, 50% of the days is below that, and that's what it's done. So essentially they've granted a water right to fish. Remember that minimum in-stream flow is a water right for fish. They've granted a water right that does not exist. The next slide here is, there's been a lot of comments in the paper about this in the past, but essentially ecology fails to comply with state law. And what we have here is ecology has a regulation, adequate and safe supplies of water shall be preserved and protected in potable condition to satisfy human domestic needs. The first section here, February 7, 2000, is one of the final drafts of the 2001 in-stream flow rule that included a paragraph for you and I. It would have been livable, would have provided us some water. This was at the end of all the research that they had done. But 11 months later, 12 months later, this is what they filed for state regulation. They just completely, arbitrarily took that paragraph out. There are no notes as to why it disappeared. It disappeared. Now, in all of my digging of ecology notes, there's a few things that have come up, and I have all of these in their entirety, but I received these from, they were down in Olympia. April 27, 2000, so 2 to 3 months after that paragraph was in there. This is a clip from Ecology Internal Notes that says, Dan would like to exclude exempt wells, but there does not seem to be a clear justification. And then my favorite, we don't know the effect of permitted wells on streams. This whole rule is about your well impacting streams. And here we have them admitting they don't know it, yet they passed a regulation. The next part I have is notes about exemptions. And it says, new language is needed to fully state that tribal rights are not affected by the rule. Now, I don't have a problem that it says we need to protect tribal rights. I have a problem that they don't have protect tax-paying citizens' rights, because that's what they did. They took your water away. The last example I have here, there's 2 in here talking about basically the science or the poor arithmetic. The first one is Carpenter Fisher. We all know where it's at, south of town. And then there's that one measurement point for the main stem of the river. It is physically impossible and irrelevant for any water use in Carpenter Fisher. There could be 1 million people living there or 0 people living there. Whatever water use occurs in this area has no relevance to a measurement station upriver. 12.37 miles upriver. Pardon? River mile. Yeah, river mile. The next example I have here kind of stems from a conversation I had with a Anacortes City Council member. She had talked to me and said, there could be 20,000 people putting wells in the ground potentially. That's gonna, it's detrimental to fish. It's just, we can't do that. We've got to cap it somewhere. I said, okay, well, let me take that example. We got approximately, give or take, 6,000 landowners. Let's say all 6,000 of those landowners divide their property by 4. They want to do a mini development. So it's 24,000 wells. So that's a lot of wells, a lot of development. Now remember, the state average is 350 gallons a day. So I'm giving you an example here. 24,000 wells, 500 gallons a day, everyone's going to use. and 100% connected to the river at one point, right at that measurement station. Because remember, they only did one measurement station on the river, and a 50% septic recharge. That is the amount of water that it would use. Approximately 9.2 CFS, or 0.092% of the minimum in-stream flow. The depth of the river would change that much. But what's worse is that the measurement station used to administer this law has an accuracy of 0.01 feet. It cannot measure the impairment that you may have in 50 to 100 years. What's worse is that at this measurement station, the river depth changes over a foot daily. You can go on USGS and look at data if you like data, and you can see all of this. So there's absolutely no way they would ever be able to measure your impairment. Yeah. Now, the other thing, I've got a couple more slides here. There's always a lot of talk about how collaborative this has been. You know, whether it's Anacortes pointing fingers at Skagit County, or PUD at Skagit County, or Swinomish Tribe at somebody. Everyone talks about how collaborative we were in '96, but how we aren't now. And you know, the Swinomish Tribe had an article in the paper, or an ad, about 1.5 years ago. It talked about collaboration in the Skagit for plentiful supplies of water for people and salmon. And it talked about the collaboration of the 1996 agreement and how they are abiding by that today. Well, we know that Skagit County claimed breach about 1 year ago of that agreement, and here's one of the reasons why. You know, it's not just all this hearsay. There's actually, Robert L. Wubino was a consultant for the 96 MOA, and this was taken from a deposition he did for Skagit County back on May 3rd, 2005, when they were getting ready to sue Skagit County. And it says, so your concern about the in-stream flow rule was that it didn't make a provision for exempt wells above the pipeline crossing. I think the Board of Ecology screwed up. That same issue is across the state right now. They have the same problem all across the state. But the last two sentences are the best. And they made a provision without addressing the intent of the MOA as well as the intent of the planning process. So everyone can claim what they want, but the 1996 MOA was breached. So we talked to Skagit County commissioners about this and a number of other things, and they provided information to us that was said to them, and I think it's important for all of you to hear it as well.
Subject. I've heard that Brian Kalusny, the Swinomish Tribal Chairman, has said that as far as he's concerned, water restrictions in the Carpenter Fisher Basin are not about fish, but rather about controlled land use.
I asked Chairman Cladsby if we couldn't find a way to settle the water issues for all of our citizens. Our children and grandchildren wouldn't have to fight about it. And he told me that with utilities you control land use, and that he intended to control land use in Skagit County. So that's what he said.
This doesn't look much like a story.
So Skagit County's involvement through this. This is very simplistic slide. I'm not going into great detail. They've done a lot. They represented you in the 96 MOA. They spent millions, and I don't know how many millions, I've heard 5 to 10, to get that 2006 amendment that would have given you that slice of the pie. That was invalidated last October. And in the last year, they claimed breach, and they've essentially walked away from the situation. And one thing I will note is that for me, my property was in Snohomish County, and as soon as I got wrapped up into the moratorium 3 years ago, my property dropped. It went from 150 to 36. So 150,000 to 36,000. They got right on it, dropped it. Skagit County hasn't done it, and I think you have to appeal your property to get your values changed.